Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a fantastic show for you today, so let's give you a preview. First, the man who was apparently the most honest and upstanding attorney, now disbarred attorney, Alex Murdaugh, has a couple of murder charges to accompany his other legal woes. We've received copies of the motions filed by Lori Vallow's attorneys, and frankly, that's good lawyering. An espionage trial concludes. Kevin Spacey says not guilty in a British courtroom. And then finally, our dumb criminal of the day. Let's talk about it. Let's go ahead and open the record for July 14th, 2022 and get right to the news. First, that's right, Mr. Alex Murdaugh is already behind bars for separate charges related to embezzlement and fraud, and it's unclear when he will be arraigned for the murder of Maggie and Paul, who were shot dead on his family's estate on June 7th of 2021. Now you have to remember, that's Mr. Murdaugh's now deceased wife and son. Well, he was indicted by the Colton County Grand Jury on 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime after allegedly shooting Maggie with a rifle and Paul with a shotgun, according to the 8-page indictment. Now, a capital offense in the state of South Carolina that could see him face the death penalty if he's ultimately found guilty. Now, the property, which was actually in Maggie's name at the time of her death, was recently sold for $3.9 million, and those funds have already been earmarked basically for the numerous creditors that have come calling. Now, the property has now been stripped clean and abandoned. It's hard to believe that really it's been over a year ago. On June 7th, the family hunting lodge was a grisly crime scene. Ground zero for what would turn out to be a labyrinth tale of betrayal, fraud, addiction, and murder, with a failed suicide for hire plot and a suspicious death thrown in for good measure. 13 months ago, Alex Murdaugh told police he found the bodies of his youngest son and wife by the dog kennels when they returned to the family's 1,700-acre hunting estate of Mosul around 10 p.m. Audio of the 911 call that he placed at approximately 10:07 p.m. that night, he can be heard telling the dispatcher in the high-pitched screech, "I need the police and an ambulance immediately. My wife and child were just shot badly." Paul, 22, was shot twice with a shotgun, once in the head and once in the chest. Maggie had been shot multiple times with an assault rifle. Their gunshot wounds were believed to be consistent with an execution-style killing. Now, according to several sources, Paul's body was found partially inside one of the kennels, while his mother's was several feet away, leading investigators to believe that she ran from her killer before being ultimately gunned down. At least 2 of her gunshot wounds were believed to have been inflicted while she was on the ground. Now, if the dogs barked that night, they did so in vain. According to Murdaugh's lawyers, Murdaugh had an ironclad alibi, and his marriage with Maggie was nothing but full of love. But in the intervening months, a few different pictures has emerged, casting doubt on both claims, with evidence and witness testimony likely that was heard by the grand jury. Now, Murdaugh's alibi has apparently changed significantly since his initial claims that he was nowhere near the property between 9 and 9:30, the time the coroner gave the approximate time of death. Now, in the immediate aftermath of the crime, Murdaugh told investigators that he was visiting his dying father and his mother roughly 11 miles away at their home in Varnville at the time of the murders. Now, 2 weeks later, his brother, John Marvin, and Randy Murdaugh told Good Morning America that he had dropped his father at the hospital in Savannah before visiting with his mother, who has dementia. According to an interview given by Murdaugh's lawyer, Murdaugh claims to have left the property around 9 p.m. to make the 20-minute drive to his mother's house and return to the Mosul property as originally claimed around about 10 p.m. Now, it is an account that places him squarely on the scene within the time frame of the killings. It had been speculated that audio and video data gleaned from Paul's cell phone found by his body, but only recently unlocked by law enforcement, is what prompted Murdaugh's dramatic change of tune. There have been reports that this audio and video data shows Murdaugh speaking with Maggie, but that the high-velocity impact spatter of blood found on his clothing that night places him at the scene of the murders when at least one of the victims was killed. Now, for the last 13 months, several theories emerged regarding the Murdaugh murders. There was the ornery groundskeeper theory, at whom Paul Murdaugh had allegedly screamed over the alleged seeding of a dove field, and that might have been what started it all. Perhaps revenge in regards to the death of Mallory Beach for the fatal boat crash in 2019. Maybe it was the 2015 death of a young gay man to which the family was rumored to be connected. Now, the Murdaugh family was to be running their own independent investigation, and they originally offered a $100,000 reward for information. But that reward money had an expiration date. That's something you don't always see. Well, the narrative changed when Murdaugh was arrested in a bizarre roadside shooting in September. Murdaugh was a drug addict, apparently they said, had been stealing from his law firm to support his habit, and the killings were potentially related to those thefts. Now, soon Alex Murdaugh was facing 85 charges, the majority of which are related to the scheme to steal millions of dollars from his clients' law firm and friends. Two of the charges are related to an alleged drug trafficking conspiracy. Murdaugh, who said to have had this ironclad alibi on the night of killings, remained the only public named person of interest in his wife and son's death. But as time passed with no charges and no updates from law enforcement, a lot of people began to wonder whether investigators would solve the case at all. I certainly did. Speculation about the Murdaugh family's connection would maybe make some people think that this thing was just going to go away, die on the vine, so to speak. Well, the indictments handed down Thursday do not provide any detail about what the investigators think happened that night when Maggie and Paul were actually killed. This means it's not clear who investigators believe was killed first. It also means that the motive has not been made public. A press release from SLED and the State Attorney General's office did not explain why authorities took 13 months to charge Alex Murdaugh, but the statement issued from Murdaugh's attorney is demanding a trial in 60 days. That is where things are going to get good. They only have 60 days from the date of arraignment to get to trial. Well, we've seen how that has worked out for other cases that we've talked about. Usually works out pretty well for the defense. A lot of moving pieces, but when you indict, you tell everybody, the court, the world, the defendant, that you are ready to go and you can prove your case within 60 days. So Murdaugh attorneys have provided a statement through their law firm denying Murdaugh's culpability in Maggie and Paul's murders, and that states, quote, Alex wants his family, friends, and everyone to know that he did not have a thing to do with the murders of Maggie and Paul. He loved them more than anything in the world, end quote. I can hear the opening statement now. Ladies and gentlemen of the jury, Mr. Murdaugh has made some mistakes, but he is not the one that killed his lovely wife and young son. This is going to get interesting, ladies and gentlemen. I told you when the boating accident happened, something just didn't smell right, and here we go. Now, not to be too excited because of one man's tragedy, but it can be said it's another man's opportunity. We get to figure out what happened, and hopefully there will be justice for everyone involved. But before we get to the Lori Vallow matter, please subscribe if you have not done so. Like the video if you do, and hit that bell so that you receive notifications when we go live or put up new content. As we said yesterday, Lori Vallow's attorneys have filed a couple of motions yesterday, but of course, because of the delay in the Idaho public cases of interest file, nothing seems to make it there with any sense of urgency whatsoever. It's kind of my pet peeve. In today's world, if it gets filed, everybody should get to see a copy of it. Anyway, here we are. The motion that was filed on behalf of Lori Vallow through her attorney, Mr. John Thomas and James Archibald. First, motion to remand indictment to the grand jury for further proceedings. Well, that's an interesting motion, no doubt indeed. But the question then becomes, what is that about? Well, let's take a look. So like all good motions you have to file, it's a good way to do legal writing is you start out with the facts. And in this particular case, they said, hey, the defendant in this case has been charged with conspiracy to commit first-degree murder and grand theft by deceptions in count 1 and 3 of the indictment. Count 1 as to Tylee Ryan and count 3 as to J.J. Vallow. The defendant sees each of these as 2 separate allegations and 2 separate acts, which, if proven, cause 2 separate crimes. The allegations allege the single crime of conspiracy to commit first-degree murder and grand theft by deception. It references 5 separate state statutes, which I won't read to you, and the statutes do not overlap in their elements. To lump first-degree murder and grand theft by deception into one charge is contrary to the statutory construction, contrary to the Idaho Rules of Criminal Procedure, Rule 8, as well as, frankly, just being confusing to the grand jury. They argue that it is unclear as to whether or not the grand jury properly found that each element of count 1 and count 3 of the indictment was valid, as the grand jury deliberation is secret, and basically no one but the grand jury themselves know if the elements satisfied Idaho Criminal Rule 6.5, which states that there may be 2 or more separate charges in a grand jury indictment, but each must be voted on separately by the grand jury. So the defense is asking and stating that it is unclear if the grand jury is alleging a conspiracy to commit grand theft by deception while in the commission of the first-degree murder. And if that is the case, then the defendant would ask that the court strike the first-degree murder language, as it is not an element of the crime of grand theft, and vice versa. If, in the alternative, the indictment contemplates a conspiracy to commit first-degree murder, and while doing so also committed grand theft, those crimes are separate and distinct, and would need to be separated into 2 separate distinct charges under Rule 8. Now, some people may say, why are they doing this, Scott? Well, this is called the law. This is called due process. This is a good argument. It goes to the essence of, did the grand jury basically get instructed by the prosecutor correctly? And now, is the indictment sufficient as it relates to these counts 1 and 3? Remember, when the district attorney or the United States attorney goes into the grand jury, there's nobody from the defense there. There's nobody to question anything until the grand jury transcripts are released and unsealed for the parties in this particular case, like all cases. And then that is the time for the defense to challenge deficiencies in the grand jury process. Now, I think this is a very interesting argument. It's good lawyering. It's doing what lawyers do. Basically saying, hey, you guys messed up the indictment. Sorry, you're going to have to go back and do it again. Or maybe we can, get a little bit of pressure here and try to change your mind. And they cite some authority for this. The defense says the United States Supreme Court reversed the defense convictions on the ground that he was convicted of a different crime from that charged in violation of the Fifth Amendment. Basically what they're saying is, hey, you think my client committed these charges? You should have charged them separately. You can't lump them all in together. It's not an element of the crime. You're creating confusion, hate, and discontent. And the appellate courts, particularly on a case that involves the potential of death, you got to get it right. So, at the end of the day, do I think the judge will, in fact, grant this motion? Because what the defense is asking for in their prayer for relief is that the request is that the indictment be returned to the grand jury for further proceedings, consistent with the severance of the charges of count 1 and 3, and in the alternative to strike the language as to either of the grand theft or to the first-degree murder in each count. See, the defense is whittling away, tearing it apart, trying to see what they can come up with. It's a death penalty case, ladies and gentlemen. That is good lawyering. My hat's off to Lori Vallow's attorneys. The judge may say, are you so confused you don't know what you're being charged with? Probably not, because they figured it out. And the court could say, more than likely, we will address it at the jury instruction charging conference, and we'll make sure that all of the elements are laid out at that appropriate time. In theory, though, it should be fixed. Had they proceeded by complaint and information, it's a quick fix. The fact that it's an indictment, not a quick fix. You got to go get the grand jury that did it if they're still assembled. And if they're not, then you need to basically go present it to the grand jury again and make those changes. Good lawyering on the part of Lori Vallow's attorneys. I assure you the DAs are going to say no big deal. More than likely the court will say no big deal, but I'm just telling you, good argument. Right, next on the docket, a spy has been found guilty. This young man, Joshua Schulte, he's 33. Well, he was convicted yesterday of leaking classified CIA information to WikiLeaks back in 2017, and he was found guilty in federal court on 8 espionage charges and 1 obstruction charge over the so-called Vault 7 leak. Now, Schulte, who chose to defend himself, not usually a good thing, but it sounds like he did okay, told the jurors in his closing argument that the CIA and the FBI made him a scapegoat for the embarrassing public release of a trove of secrets. The leaked materials concerned software tools the Central Intelligence Agency used to surveil people outside the United States. I'm sure that's only where it's used. Through such means as compromising smartphones and internet-connected TVs. Imagine that. You think somebody could actually listen in on that stuff? Who knew? Well, the United States Department of Justice said Schulte was motivated to leak the materials out of spite because he was unhappy with how management treated him. That makes a whole lot of sense, doesn't it? Oh, I don't like the way management treats me. I'm going to release all our spy secrets to our enemies. Seems a little overboard, but hey, you can't predict what people are going to do these days. So prior to his arrest, Schulte had helped create the hacking tools as a coder at the CIA headquarters in Langley, Virginia, and the leaked materials concerned software tools the Central Intelligence Agency used to surveil people outside the United States through such means as the smartphones and internet TV connections like we discussed. In his closing argument, Schulte claimed he was singled out, even though hundreds of people had access to the information at issue. Hundreds of people could have stolen it, he argued. The government's case is riddled with reasonable doubt. He added, there's simply no motive here. Well, can you imagine? The United States attorney disagreed, and he obviously encouraged jurors to consider evidence of an attempted cover-up, including, that's right, a list of chores Schulte drew up that had an entry, wait for this, delete suspicious emails. Wouldn't you just do that? Wouldn't you just do that, not put it on a list? Needless to say, the United States Attorney said Schulte leaked the information to the public and to U.S. adversaries, some of the nation's most valuable intelligence-gathering cyber tools used to battle terrorist organizations and other bad forces around the globe. The prosecutor said Schulte knew the leak would render the CIA's tools essentially useless, having a devastating effect on our intelligence community by providing critical intelligence to those who wish to do us harm. Prosecutors also alleged that while he was behind bars awaiting trial, Schulte continued his crime spree by trying to leak additional classified information as he carried on an information war against the government while in custody. Well, the judge complimented Mr. Schulte on his closing argument. The judge stated, Mr. Schulte, that was impressively done, and depending on what happens here, you may have a future as a defense lawyer. Now, a mistrial was declared in Schulte's original 2020 trial after jurors deadlocked on the most serious counts, including illegal gathering and transmission of national defense information. Mr. Schulte told the judge last year that he wanted to serve as his own attorney for the retrial, and he has not announced whether he wants to represent himself at the next trial, which involves allegations that he, when he left the CIA, he moved to New York from Virginia with a computer that contained images and videos of child pornography that he had allegedly downloaded from the internet going back from 2009 to 2017. Schulte was originally arrested in August of 2017 and had been held behind bars without bail since 2018. Last year, he complained in court that he was the victim of cruel and unusual punishment awaiting the 2 trials in solitary confinement inside a vermin-infested cell of a jail unit where inmates are treated like caged animals. You know, it used to be that when you had to pass a security clearance, they did a big old background check on you. They looked to see if you were stable, Did you have any weird sexual proclivities? Are they not doing that anymore? Because it sure seems like a lot of these guys that get in trouble leaking our national secrets usually have something that's going on. Maybe they need to check into that a little bit, because that used to be the reason why if you had those proclivities, you couldn't be in the national intelligence community or held certain top secret secrets, because you could be blackmailed into doing things. Apparently, that's not a thing anymore. Next on the docket, Kevin Spacey says, "I am not guilty." So Kevin Spacey pled not guilty today to charges of sexually assaulting 3 men in England a decade or more ago, and was told that he would face trial next year. Spacey stood in the dock and spoke clearly as he replied not guilty to each of the 5 charges during a hearing at London's Central Criminal Court. A date of June 6, 2023 for the trial has been set to start, and it is estimated the trial will last 3 to 4 weeks. Now, Spacey ran London's Old Vic Theatre between 2004 and 2015 when these alleged incidents allegedly took place, and he denied 4 counts of sexual assault and 1 count of causing a person to engage in penetrative sexual activity without consent. The incidents allegedly took place in London between March of 2005 and August of 2008, and one in Western England in 2013. And finally, our dumb criminal of the day. But as a quick reminder, that's right, you can download us and listen to us on any of your favorite podcasting apps. Just simply type in CrimeTalk, and you can go to Apple Plus, Spotify, Audible, and we are there. We are so close to 1 million downloads. Come on, let's help out CrimeTalk get to 1 million downloads. All right. Now, a Florida man has been arrested after impersonating law enforcement in an attempt to have his ex-girlfriend arrested. The Monroe County Sheriff's Office says that Claude Francis Tristram of Key Largo began violating a court-ordered injunction in March when he contacted his ex-girlfriend. An investigation revealed that Tristram began calling, texting, and mailing the victim USB devices that contained messages. He also used a phone application that allowed him to conceal his identity by changing the user's display number. In late March, Monroe County's 911 communication center received a phone call from someone claiming to be an off-duty New York State trooper. The individual reported a possibly intoxicated driver who was drunk. Responding deputies found the suspected vehicle, and the same time they were also approached by Tristram, who attempted to assist deputies by identifying the vehicle. How helpful. He also provided knowledge of where the driver was heading, which happened to be his ex-girlfriend's residence. Deputies stopped the vehicle but found the driver, Tristram's ex-girlfriend, was not impaired at all. She told deputies that she believed Tristram was behind her traffic stop and that he was harassing her. Following a brief investigation, detectives were able to trace the fake DUI report to a phone application that blocks the user's display number, and after obtaining records from the company, they were able to show that the call originated from Tristram's account. They subsequently contacted New York State Police, who confirmed that they did not have a trooper by the last name of Tristram. Bad news for Tristram. He was arrested and charged with false impersonation of a police officer. That's just dumb. That's just dumb. I actually have one of those cases going on right now, and you just think, wow, why did you think that would be a good idea? Don't get it. All right, before we close the record, that's right, I told you the cool merch has arrived. Check out this bad boy. Check out that. Is that not a good looking shirt? And oh, so soft, so soft. Can't wait to put it on. So if you would like to get some cool Crime Talk merch, simply go to the link below, and I think you can order it, and you will have it to your house or apartment or wherever you reside in probably a week. All right, let's go ahead and close the record for today. We'll see you next time on Crime Talk.